In the spring of 2024, as the elected district attorney, I exposed a scandal of epic proportions in the Alameda County justice system. For at least 28 years, Alameda County prosecutors violated the United States and California constitutions by excluding Black and Jewish residents from death penalty juries. They also appear to have used the death penalty as the harshest possible punishment for Black defendants based on their race. This certainly is consistent with what we found the use of the special circumstances against Black defendants, bringing the harshest penalties on young Black men, life without the possibility of parole. The story begins with a prosecutor named James Anderson. In 1980, Anderson became the first Alameda County prosecutor to win a death penalty case after the United States Supreme Court reinstated the death penalty in 1976. Jack Anderson, by the time he retired in 2004, he boasted that he had personally sent more people to death row in California than any other prosecutor in the country. In 1991, John Meehan, district attorney, assigned James Anderson to lead the Alameda County District Attorney's death team. So from at least 1980 through 2004, we believe that James Anderson influenced every death penalty case in Alameda County. His office mate for many years during that time was another seasoned prosecutor named Jack Quattman. Quattman had been a career prosecutor who also for many years took pride in sending Alameda County residents, many young Black men, to death row. The exception for Jack Quattman was his first case, that of Fred Freeman. Mr. Freeman was tried and convicted of murder involving a robbery and sentenced to death in 1987. Quattman felt that Fred Freeman's case never should have been a death penalty case because he felt that Freeman wasn't that bad a guy. He compared Freeman's case to other shootings at the time, but it wasn't his call. It was James Anderson and District Attorney John Meehan's call. In 2005, Jack Quattman blew the whistle on James Anderson, John Meehan, and a famous Alameda County judge, Stanley Gold. Gold was an icon in Alameda County in the 1980s and the 1990s. He served until 1998. Even when I became district attorney in 2023, Gold was still a revered figure in our office. His son, Matt Gold, hired by District Attorney John Meehan in the early 1980s while his father, Stanley Gold, was still on the bench, still worked in the office when I got there. In 2005, Quattman testified under oath that Judge Stanley Gold had counseled him to remove all of the Jewish jurors from Fred Freeman's jury, and he did. Jack Quattman also testified under oath that it was a practice of the DA's office to remove all Jews and Black people, especially Black women, from death penalty cases when the defendant was Black. There was also evidence presented at the hearing in 2005 that Quattman had taught other prosecutors from around the state to follow that rule if they wanted to win their cases. Why was this claim so explosive in 2005? Because it's illegal, unconstitutional, and a violation of every prosecutor's ethical duties. Not only is it cheating the system, it is prosecutorial misconduct of the worst kind because it involves the death of another human being. In 1978, in People v. Wheeler, the California Supreme Court stated, "The American system requires an impartial jury drawn from a cross-section of the entire community and recognizes that eligible jurors are to be found in every stratum of society. Any system or method of jury selection which fails to adhere to these democratic fundamentals, which is not designed to encompass a cross-section of the community, or which seeks to favor limited social or economic classes, is not in keeping with the American tradition and will not be condoned by this court." In 1986, in Batson versus Kentucky, the United States Supreme Court made it the law of the land that it is unconstitutional to eliminate jurors based on their race. But in June of 1992, at a statewide training class for prosecutors, and again in court in March of 2005, Jack Quattman disclosed that Alameda County prosecutors had, in fact, been violating the Constitution to discriminate against Jewish residents, Black residents, and Black defendants on the basis of race and religion. So in 2024, we had to determine who knew what when and how many bad apples had spoiled the barrel. We looked at all the death penalty cases where the defendant was still alive. According to the New Yorker magazine investigation, there are more than 600 people still with death sentences in California, more than in any other state. 34 of those living defendants were prosecuted by the Alameda County District Attorney's Office. The person at the heart of the scandal was James Anderson. Based on his own notes, his public comments, and the results based on a review of his jury selection in death cases, it did not take much to conclude that Mr. Anderson's actions violated the California and the United States Constitutions. But in 2005, the District Attorney's Office circled the wagons and, under the leadership of then Deputy District Attorney Morris Jacobson, attacked Jack Quattman. Quattman was a top gun in the DA's office for decades. He served in the DA's office for 25 years. He shared an office with Anderson on the 9th floor. He and Anderson reported directly to Chief Assistant Tom Orloff and District Attorney John Meehan. He recruited or represented the District Attorney's Office at CDAA, California District Attorneys Association conferences across the state, training other prosecutors from around the state. In 1998, Jack Quattman left the District Attorney's Office and moved to Montana. When he blew the whistle in a failed effort to save Fred Freeman's life, his former colleagues turned all the way against him. No less than 8 current or former prosecutors lined up to trash Jack Quattman in court, calling him unethical and untrustworthy. DDA, Deputy District Attorney Morris Jacobson, headed up the DA's defense team and sent DA investigators to Montana to, quote, dig up dirt, close quote, on Quattman. According to one of the inspector's notes, District Attorney Jacobson made it clear that they were not supposed to document their activities just in case. The District Attorney's Office paid for lawyers from Montana to come and testify to trash Quattman's character with what the New Yorker magazine described as petty complaints. 6 days before Jack Quattman testified in court, James Anderson admitted to a New York Times reporter that the office did exclude many prospective jurors, including Jews and Blacks, because of their backgrounds, professions, and political beliefs. According to James Anderson, it wasn't because of prejudice, but it was because, quote, their politics are not going to be on your side, close quote. Predictably, the court ruled against defendant Freeman, found that Quattman's allegations about Stanley Gold were not true, and that Quattman was dishonest and unethical. Fred Freeman died in prison 4 years later in 2009 at the age of 69. Fast forward to 2024, and we found notes in numerous death penalty cases, files identifying Black and Jewish jurors, belittling them based on their race and their religion. Most of the notes from Anderson's cases were mysteriously missing from the files. The notes we did find implicated Anderson, Kenneth Burr, Colton Carmine, Morris Jacobson, and of course, Judge Stanley Gold. Both Jacobson and Burr had also gone on to become judges in Alameda County. Their supervisors, whom we believe were aware of their misconduct, included District Attorneys John Meehan, Tom Orloff, and Nancy O'Malley. When the New Yorker magazine confronted Anderson with the notes and the evidence to confirm Jack Quattman's allegations of prosecutorial misconduct in 2024, Anderson claimed that prosecutors were told to purge their files because of the office's limited storage space, as an explanation for why his files had been purged. He also claimed that I was undoing the hard work that they had done because of race, claiming that I was only trying to undo the cases of black defendants. Not only was that not true, but in the Curtis Ervin case, the California Attorney General's office conducted a comprehensive review of Mr. Anderson's jury selection practice and concluded on its own that Mr. Anderson had violated the United States Constitution and that Mr. Ervin was entitled to a new trial, which the court granted. When I was recalled in 2024, state bar and judicial misconduct complaints were pending against 7 former members of the Alameda County District Attorney's Office based on the notes we found. These lawyers are still alive and some are still practicing in Alameda County. Even those that have passed on, their living legacies are in the DA's office. Matt Gold, the son of Stanley Gold, who left the office after the scandal broke in 2024, was recently rehired by the new district attorney. DA John Meehan's son, James Meehan, who was hired by his father 38 years ago, is still in the office. In 2024, we found 11 deputy district attorneys hired by District Attorney Tom Orloff, whose parents either served as deputy district attorneys or they were judges in the Alameda County Superior Court. During the dark era, when by James Anderson's own admission, quote, there was nothing we couldn't get away with, close quote. Now that the old guard is being restored to power in Alameda County's justice system in 2025, the question the public should ask is whether a few bad apples spoiled the whole barrel. Are the days when Alameda County prosecutors and judges willfully violated the Constitution truly over? Or is the desire to return to the good old days leading us back to a dark place riddled with injustice? As someone once said, history may not repeat itself, but it rhymes often.